Happy New Year and welcome to 2021. And this evening we are joined by Waikwa Wanyoike from London, who we've interviewed before. Karibu Waikwa, and Happy New Year to you. Waikwa is the immediate former Executive Director of the Katiba Institute and a pioneer in public interest litigation here in Kenya, and currently with Open Society Foundations in London, still focused on the same area of public interest litigation. And karibu sana and Happy New Year, Waikwa.
Happy New Year, John, and asante sana for having me again.
Waikwa, let me start. I mean, we had agreed on talking about some subjects, but events in the United States yesterday, the US is the democracy that is the model for many of the democracies in many developing countries in terms of constitutions, in terms of institutional structure, etc. American experts are essential to the design of many of our institutions, many of the constitutions across the continent. And whenever we have an election, they are here, they are advising, they are helping to fund. But what we saw yesterday, and what we've seen actually over the last number of years, but culminating yesterday in this sort of very unusual, extraordinary events in Congress, what are the implications of this? I mean, it's still early for democracy. I've seen a lot of very satisfied autocrats around the world commenting almost sarcastically that the US should calm down, and they're calling for peace and understanding. Playing back the kind of statements that are usually played to us in developing countries by US ambassadors, who seem to have all gone off Twitter over the past 24 hours.
No, I think it's actually quite an interesting time. Whether you look at it from what the reaction from the rest of the world has been, including from countries that US has been having significant beef with. So, for example, some of the statements I saw came from even Venezuela. And other countries, as you've alluded. So it's very interesting about the moral authority of US as the symbol of democracy in the world. Certainly these events have significantly questioned that issue, whether US can still continue to claim moral authority. There's also the question about the working of the Constitution and the law. And in fact, whether what we've been told over the years, that America has the greatest constitution in the world, is true. Some of us have always questioned whether the American Constitution is modern enough to be able to respond to modern issues. Remember, the crisis yesterday was about certification of the Electoral College, which, as you know, it is the process of formal process of electing the president, because the president is actually not necessarily elected through a popular vote per se. And so there are people who've questioned, does Electoral College have relevance in this day and age? And so if, for example, there was no Electoral College, would this have come up? Of course, there are people who will argue that even the popular vote, Trump has disputed that, and so there would have been an opportunity maybe to dispute that. But I think for me, from a constitutional point of view, it's this crisis, and it's not just yesterday. Remember, just before yesterday, over the weekend, there was this controversial call that Donald Trump made to the Secretary of State of Georgia, trying to influence the votes and requiring him to find him, I think it is $11,780 votes, just to make sure he had one vote more to win the state. And what happened there, back and forth between him and the Secretary of State. But so from a constitutional point of view also, I think what this has demonstrated, even assuming we were to accept the thesis that America has a great constitution, that it's not just a constitution you need. While constitutions are critical in terms of being markers and guardrails of what is acceptable within the society.
Yes.
I think what it's demonstrated is that you need more than the constitution. At the minimum, you need good manners. And in my view, American democracy has not necessarily worked because of having a great constitution, because I actually contest that. I think American democracy has worked because generally there has been leaders and people in positions of authority have decided to comply with what the law requires. Of course, Trump has come and actually questioned that. So it's very interesting, but it brings us also to our own problems, whether it's in the continent of Africa or other places that are having problems in terms of rule of law.
Yes.
And a reminder that when you have a leader who is willing to be so selfish, and that has been the problem with a lot of our countries in Africa, and who is willing to manipulate the law, to manipulate the people, to manipulate institutions, as we've seen with the Congress, that senators and House of Representative members, they really, a lot of them have been relying on whether they think their electorates will support the positions they take, not necessarily what the law requires them to do. So when you have such individuals, then it becomes very difficult to instill a proper rule of law culture. And it just shows how easy you can destroy one.
Yeah. Thanks. I'm sure this is a subject that we'll come back to as it continues to play out. There's still a couple of weeks left in Mr. Trump's tenure, and I'm sure there'll be some interesting developments. But coming closer to home, Waikwa, I'm sure you've been following over the Christmas break, and through December. We now have a plethora of litigation around the Building Bridges initiative that has gone to court, and it's bouncing around in the courts. And I wanted to ask whether you can break down the various challenges or the various cases that have been brought around the Building Bridges initiative in Kenya over the past year, their implications, and what each of them are actually trying to achieve. Just briefly, just for people who are not legal experts, we can see that people are taking these issues to court. What are they challenging, and what are the potential implications?
I think sets of cases that we've seen. So the first cases go back as early as beginning of 2020, and in fact, late 2019, early 2020. The cases brought in 2019, there are at least 3 cases starting from 2019 that were challenging the Building Bridges Task Force. One of those cases was decided at the High Court, where the specific question there was whether the president had powers to appoint a task force. And the judge said that he believed that the president had the powers. But there was a second case and a third. The second was brought by Okiya Omtata. That case actually questioned not only the president's ability or powers to appoint a task force, but whether to appoint a task force whose intention is to change the constitution or to take over responsibilities that are already assigned to other institutions. So when you think about it, For example, in relation to the initial message that we were given as to why there was a building bridges initiative, it was more about national cohesion or fostering national cohesion. But we already have a National Cohesion and Integration Commission. So when you go through every subject that was covered by the Building Bridges initiative, there was always, you could always allocate it to an existing institution. So there was that, but there was also the general question in that first part of those first cases. There was the general question about whether, in fact, if the disappointment of building bridges, whether it should have been competitive, whether it should be using public funds and such. Unfortunately, the case brought by Okia, which is quite consequential, for whatever reason, judges seems to have found ways to delay it, and up to this time, even though it was brought in January 2020, it's not been decided. Okay. The second set of cases are the cases that started the moment it was clear that BBI was going to go ahead with constitutional amendment. And there are quite a number. In that, so in the second phase, there's category 2 and category 3. The first category are two cases that have gone to the Supreme Court directly to request for advisory opinion. That's a case brought by Kericho and Nandi County, and then a case brought by the governor of Makueni. Both of them now have been consolidated. And they're asking very interesting questions. So they start by asking, for example, can the state or a state officer amend the constitution using a popular initiative? Or is the popular initiative only reserved for citizens because state and state officers can use a parliamentary process to amend the constitution? The second set of questions is, what does amending the constitution or bills to amend the constitution mean? Should a bill be containing 100 different issues? So, for example, we know the Building Bridges Initiative bill is covering at least 13 chapters of the Constitution. The Constitution only has 18 chapters, yes. And has issues, and this has been done by the legal team representing Governor Kibwana and Governor Kibwana. They have found 78 different distinct issues that are proposed to be changed, not provisions, but different issues. So then the question becomes, can you do that? And if you are allowed to do that, then how easy is it to overhaul the constitution using the amendment process? Then the other question, mostly from the county assemblies, is the process under which county assemblies have to consider the bill when it comes to them, yes, including issues of public participation. And there is also the questions, finally, of when eventually we go to a referendum, if we get there, is the question to be presented one question or multiplicity of questions, if it's possible to pack so many issues in an amendment bill? So those are the questions before the Supreme Court, and the Supreme Court has already started considering that. The Supreme Court asked for an opinion from the Attorney General. That opinion, I understand, has already been delivered, and there is a date for the court to consider the next step on January 20th. Then the third and the final set of cases are cases that have been brought to the High Court to try and stop the process of BBI. Yes. Whether those are cases that were brought before the signature collection process was finished, or the ones that have been brought after the signature process has been finished and they have actually already been submitted to IBC. The latest, obviously, by Muhuri, questioning whether, in fact, IBC has the capacity to verify signatures, given that they don't even have a database of specimen signatures for registered voters, as well as the fact that there is no regulatory framework to help govern the process of verification and other processes of amendment of the constitution. So I would put them in those three categories. Of course, there are different implications that come from all of them, or they may have different implications.
You mentioned IEBC there, and I just wanted to ask, what is the provenance of IEBC since the 2017 elections? It's lost some commissioners. The commissioners seem to have left and they came back. It's been slightly confusing. What's the exact status of the IEBC right now? And it continues to conduct by-elections, and it's now slated to hold a referendum and a general election. But what's the legal status of the IEBC to be able to do this? And is there a risk that some of the processes that it embarks on can be challenged later as a result of its own sort of legal provenance under our constitution?
That's actually quite a complex subject matter, and it's complex for a number of reasons. The first thing is the law requires that IEBC has to have 7 commissioners.
Yes.
And the law further requires that a third of those commissioners, or not more than 2/3 of those commissioners, can be from the same gender.
Yes.
What we know now is that we have 3 commissioners,
yes,
who are all male. So there is a question about the legality of IEBC, first of all, in terms of the composition, whether in fact they should be 7.
Yes.
The second is whether when you have even 3 of them, because under the constitution, commissions generally
yes,
can have a minimum of 3 members and a maximum of 9.
yes,
So one could argue that at least they have the minimum that is required by the constitution, but at least they don't have the gender quota that is required by the constitution. So in a way that makes the composition of IEBC unconstitutional and illegal.
yes,
Why it gets more interesting is that is the question whether, because the composition of IEBC is illegal, that means that the commissioners themselves are in office illegally. In my view, they are not. But then because it's not their own doing that there are 3 and only 3 men. That is the failure by the president and other institutions that are supposed to be putting in place mechanism to appoint commissioners. Remember, the law, the IEBC Act, requires that whenever there is a vacancy in an office of a commissioner of IEBC, that the president has to start the process of recruitment within 14 days. That was never done. It's, I think, over 2 years now since the commissioners resigned. So the failure and the delinquency that we have at the moment comes from the president and other institutions that are charged with the responsibility of appointing other commissioners. Of course, because of the political interest in IEBC, I think it's very, very intentional why it's been left like that, so that it's easier to be politically manipulated. The third point I wanted to make about IEBC and why this question is complex is because in 2018 or 2019, somebody went to court and challenged the capacity of IEBC to conduct a by-election on the basis that there were only 3 commissioners, and that the composition wasn't constitutional. And the judge there, and we can debate whether she was right or wrong, actually found that it was okay for IEBC to go ahead and to conduct by-election, because that is an administrative function of IEBC, which is mostly done by staff, not commissioners. This is important in the context of BBI or any issue relating to constitutional amendment. Because some people would argue that it's already been found that IEBC can go ahead and conduct its activities. That's not what the judge said. The judge said it's okay for by-election because it's administrative. However, when you look at Article 255 to 257 on amendment of the Constitution, there is a question, can IEBC as constituted conduct a referendum, whether that is a duty that is actually given by to commissioners, to the chair and the commissioners of IEBC, more than it's given to the staff. Of course, the staff have to facilitate the administrative part of it. But for example, you cannot send a bill to county assembly without certificate of the commission. The commission itself is the commissioners and the chair. Yes. So there is question about that. But there is also the further question about not legality of composition necessarily, but competency based on composition. Yes. Including, for example, the question, which was never at least argued in the first time, whether the fact that IEBC is not properly constituted based on the gender requirement, then it lacks the competency to undertake certain functions. And I would argue, for example, it lacks the competency to change or to facilitate the change of the constitution, and especially when some of those changes are addressing the question, the constitutional question of 2/3. So you see why it gets a bit complicated. There are also questions about quorum and the legality of, or the ability of IEBC to have a legal quorum. There was a case in 2017 that required that the quorum of IEBC is 5 members. So the question is, how do you achieve that quorum at the moment with only 3 commissioners?
Thanks. When we last spoke, Waikwa, last year, you argued very persuasively that you did not believe, given all the hurdles, that both legal and political, that are facing the BBI initiative and the referendum, that you seem totally uncertain that the referendum would take place at all. Does this remain your position, and why?
Yes, it still remains my position. I think I gave 3 main reasons why I thought it was untenable for us to have a constitutional a referendum, a BBI referendum before the 2022 general election. And the 3 reasons were, first, that first of all, there are so many gaps in law that are so open to challenge, including just what you've pointed out about the competency of IEBC, that makes things very dicey for a process to amend the constitution. And we've seen that with a lot of the litigation that is now going on, including the fact that there is very good argument that even the basic legal framework to regulate the process is not there. And for example, we have 2 pending bills in Parliament. They're called the referendum bill, which are still going through the process. Yet we are having, and those bills include processes of regulating collection of signatures and verification of signatures. And so if there is an acknowledgement even by Parliament that there is a gap in law, and that is why it is legislating, then why are we in a rush, and what are we using as the basis of verification or collection of signatures and verification of signatures? So there are those questions about gaps in law and illegalities, including, for example, the process that BBI has used, which is a popular initiative, yet the state has pumped all these resources, and whether there is that is a legal process. The second issue I had brought, the second argument I had made was that it's very hard under the 2010 Constitution to effect amendments without significant general consensus. Partly because of just how onerous and complex the amendment process under the 2010 Constitution is. And we've seen a lot of that. We've seen back and forth up to now. We are hearing people in official positions and superintending the processes of BBI are still indicating that it's still possible to negotiate some of these things. How do you negotiate when you've already submitted a bill to the IEBC? We've seen what Senator Kangata wrote the other day,
yes,
and the recommendations he made. And we've seen the general reaction by the public showing that there's probably very little support for BBI. And while the state could have forced the initial processes of creating a task force, developing a bill, collection of signatures, which we understand was done significantly through compulsion using the provincial administration, the process now has got to a place where the state itself doesn't have as much control as it had initially. So a lot of the IBC process requires adherence with the law, and that's why you're seeing a lot of cases mushrooming now. The next process, assuming it gets to the county assembly, there are questions and even getting consensus at the county assembly. And then finally, you need the absolute consensus from the people if you end up having a referendum, which is a whole other game. And the third argument I had made is that because of the time, we will be, and given how long it takes for amendments to be effected, we'll get to a place where the politicians who are pushing for BBI amendments will be forced to choose between pushing for amendments or campaigning for 2022.
Yeah.
And we've already started seeing that. I'm hearing that presidential candidates are already starting to put together campaign groups for 2022 presidential election, and even some are already starting to put together offices and other infrastructure. Yet one of the supposedly main presidential candidate is still going around trying to convince people about supporting constitutional amendment, which seems extremely toxic. And so at some points one wonders how long can you carry such a toxic agenda when you yourself or your party is interested in contesting power in 2022, and how does that affect your chances or compromise your chances come to 2022? But even assuming it's not toxic, just in terms of resources, how much resources do you need to be able to carry these two processes? And remember, we might also get into a point where even if you effect these amendments, you will not be able to use them for 2022.
Yes.
So for example, there's proposals to increase membership of parliament, including including constituencies. Already there is law, or there is a provision that says if you're creating constituencies within a certain time close to the general election, then that cannot be used for the upcoming general election. So then the question becomes, what do these people stand to gain? And are our politicians that philanthropic that they're willing to change the constitution now for benefits they'll accrue 5 years down the line? I'm sure they're not. So when you look at all these, and when you think about the fact that all these processes are open to challenge at every stage before the court, then I still believe because of timeline, because of just how many handles, because of the manipulation that we've seen, and because that there is significant pushback from the public and from a section of very known politicians, I don't think we'll be able to have a BBI referendum come before 2022.
Thanks, Waikwa. There's been another development that that is new under the 2010 Constitution, which is we've seen the impeachment of the governor of Nairobi, Mike Mbuvi Sonko. And we've already seen a number of prominent political actors throw their hat into the ring for the by-election for Nairobi governor, including General Miguna, who has been forced out of the country, who declared quite confidently that he had spoken to Mr. Waikwa Wanyoike and was reassured that he can stand and with that authority can felt confident that he can go ahead with the process. But on a most serious note is this is quite new territory for us as a country, where the impeachment of a governor or public official at that level. And I wanted to ask what the implications are in terms of how does it play out from now constitutionally? How should it play out in terms of the process, which has already gone to court? How do we go about holding the by-election and under the 2010 Constitution? How does that happen?
So first thing first, yes, it's my opinion that just because Miguna is in exile, that doesn't bar him from contesting for political office in Kenya. And that's the transformative nature of our constitution. Your rights don't get suspended just because you've been forced into exile. And legally, there are mechanisms that exist for him to be able to contest for governorship or any other state office position if he wishes to do that. And I understand he obviously is contesting or has declared to contest for Nairobi gubernatorial. But going to the other issues, there are quite a number of issues that have come up. So the first set of issues is whether Sonko, for example, or Waititu can contest for elections, especially given that they were impeached. I go back to say how complex some of these issues are, not because the Constitution made them complex, but because our practice has made them complex.
Yes.
Some people have argued that once you've been impeached by Senate, then you can't run for office. But the Constitution says that you qualify to contest as a governor if you qualify, if you meet the qualification to contest as an MCA, with an additional requirement of a degree under the Elections Act.
Yes.
Under the Constitution, and I think it's Article 193, it also says, yes, you can be barred on the basis of Article 6 type reasons, which is what impeachment sometimes entails. And in fact, in the case of Sonko and Waititu, one would argue that they were partly impeached because of violation of Chapter 6. But that provision complicates things a bit because it says that you cannot be barred if you have an appeal challenging any of the decision that has been taken, and that appeal has not been exhausted. So that complicates things because as far as I know, both Waititu have and Sonko have ongoing court matters relating to their impeachment. And so the question is, have they exhausted or are they barred under Article 193(3) from contesting, given that they have ongoing appeals? And that is a question that will have to be decided by the court. The second reason why this gets very complicated is because of what we did in 2013. In 2013, there was an attempt to bar both Kenyatta and Ruto from running for president and deputy on the basis that at that time, they had actually been indicted by ICC on serious international crime, under serious international crime reasons. And so, and that time we know that the court found a roundabout way to excuse their candidacy. I still completely disagree with that decision. I think it was largely cowardly on the court, and in fact, the manner in which the court approached it, including trying to run away from jurisdiction, but then commenting substantively on merit, was just wrong. But we have that decision, and so if it benefited Kenyatta at the time, and the same people are now arguing why people like Sonko and Waitito should be barred, then one says you cannot use the law that conveniently. Yeah. At least the courts need to come back and say, we were wrong in 2013, and this is now the law, because the court is allowed to do that. The court is allowed to revise the law. That reason why it's a bit complicated also is, in real sense, if we had implemented the constitution properly, and chapter 6 specifically, there would be no question about whether or not Waitito and Sonko can run. The answer to that question would be they cannot run. Partly because the requirement under chapter 6 has different components. There is expectation that some of the issues that may come under chapter 6 are issues that will require you going to court. For example, criminal matters and maybe matters of impeachment. But chapter 6 also contains both a subjective and objective criteria of just general behavior as a state officer.
Yes.
It is very, very difficult for somebody who's been impeached, and especially where one can say the process has been fair. It is very difficult for them to argue that they meet, their personal behavior meets the standard of a state officer required under chapter 6. And the courts in a lot of ways have failed us on that, including the Supreme Court. In 2017, Supreme Court, the Kenya National Commission on Human Rights went to the Supreme Court to ask the Supreme Court to provide the basic criteria under chapter 6 of barring candidates who have integrity issues from running for office. Supreme Court ran away from that litigation, and later on, very, very late, decided that it did not have jurisdiction. Way after 2017 general election. And we know there was a similar experience in a case brought by Trusted Society that went all the way to the Supreme Court. And the Supreme Court very casually allowed that case to be withdrawn, even though it raised one of the most significant public interest issues. So until the court actually undoes the mess, then people like Waitito and Sonko will still have the moral authority to keep arguing that they deserve to go through those processes that seems to be required by the Constitution. So we'll have to wait until that is resolved.
One final question. Time always flies when we're talking, as I said. Just a broad sort of philosophical question. I mean, a lot of what we are discussing in Kenya's history have been political contests that have taken place in Parliament, in the legislature. We have seen a fairly dramatic judicialization of our politics, where the arena of political contest has become the courts. And that has its pros and its cons in terms of the flexibility of politicians to be able to sit down and where there are disagreements to negotiate and to come to agreements, for people to stand down from positions, to compromise, etc. But we seem to be kicking all our hot political potatoes into the judiciary, and that is weighty. What would your comment be about this new penchant for taking all our political issues into the court system, and the fact that Parliament seems to have sort of almost disappeared in sort of missing in action around these major, very consequential governance issues facing Kenya?
And unfortunately, the courts are victims of the failures and basic dereliction of duty by the executive and Parliament. And why everybody ends up going to court is because other institutions are not properly functioning. And I'll give a few examples. Let's start with the executive. The reason we have an attorney general is that anytime there is questions that relate to the law, and the reason actually our attorney general has the security that the Constitution seems to offer him, and now the Attorney General's Act, is to make sure that he always gives a professional and honest legal opinion. If you look at a lot of cases brought against the state, and if you did a sampling, you'll find that in more than 60-70% of the cases that are brought against the state for state failing to do something or because it has done something illegally, those cases, the state loses those cases. Partly because the Attorney General does not do his work. He does not offer honest opinion to government, and even where he does, he's not firm enough to require government to undertake what he considers to be the right position or the right action under the law. So we've got yes men giving opinions. So for example, we saw what opinions were given in respect of the takeover of Nairobi County government, including by the National Assembly, and how the kind of processes that were used. And a lot of the time, even when they try to do something right, it's post-fact. They are trying to correct things. They should have done the right thing. And we also know how the Attorney General has continued to hold a strong position about some of the enforcement of court order, including even when the current Attorney General himself has been a judge for a very long time, including in very senior position as Court of Appeal President, and understands how the court processes work, but wants to argue with court orders when those court orders have not been set aside. But let's come to Parliament. A lot of the issues that go to court, and most of the controversial issues that go to court, is either because Parliament has not provided the guideline or the regulatory framework. We were just talking about that in the context of BBI, or the proper guidelines to guide the process. Or because Parliament, in its political and convenient way, creates laws that are just meant to conveniently favor a situation or a person, not laws that accord with the requirements of the Constitution. So we've seen a lot of laws, in fact, being declared unconstitutional. Or Parliament gets into processes that it's supposed to get into and conduct in a constitutional manner, but essentially just relies on politics. So we had Waiguru being taken to Senate and not getting impeached because she was favored by the political class or the political elite of the day, not necessarily so much because of the evidence, whether the evidence was supportive of her position or not. The main consideration we know, based on public record, was based on who was supporting or not supporting her impeachment. We've seen what has happened with Sonko and Waitito and others. At some point, impeachment is used even by Senate as a stick and not as a proper legal instrument. And of course, then those issues have to go to court, and the court is left holding the controversy. I want to give another example. I already talked about the lack of regulatory framework in the context of BBI. Parliament is supposed to have been dissolved by now because of failure to enact the gender law. Part of the reason why that became so complicated, or that issue became so complicated, is because Parliament never passed legislation to guide processes under Article 261 on dissolution when that issue comes up. Mm. So Parliament itself has gone to court to challenge that, where in fact, and sometimes I think our judges are even not bold enough, where in fact the judges need to be asking Parliament, but where you are required to enact a law to guide all these processes, where is the law? Including just procedures. For example, what happens if the Chief Justice advises the President to dissolve Parliament? What should follow? How long should Parliament take? Is it a by-election or a general election? All those questions. So at the end of the day, courts are getting all this work and very controversial work because our other institutions are failing. My concern at the moment is that the court is also feeling so much heat because not only are problems brought to them, but the problems are brought and then they start getting threatened by the same institutions. If you don't do this, this will be the consequences. And what we are seeing, and this is worrying, and Kenyans should be really worried, we are seeing the courts start to lose courage. And judges are taking longer to make hard decisions, or sometimes finding a lot of ways to make what I would call convenient decisions so that there is not too much backlash. We can argue that judges can only withstand so much pressure. We know anytime a judge issues a decision, especially that's very unpopular with the executive, we start seeing all these videos connecting the judge with the scandals that don't even exist and such. So judges are human, so they can only also take so much pressure. But the failure of courage is not just happening at the individual level of judges, but it's also happening at the institutional level. We are very lucky to have Maraga, who kept keeping his word when he says he won't do something because it's against the law. We should count ourselves very lucky if we get a similar courageous Chief Justice when the process starts, I think next week when Maraga formally retires. I am worried, just given how much heat the judiciary has had, that we will not be able to get a candidate. And the manipulation that the executive, I think, will have in the selection of a Chief Justice, we will likely not end up with the same caliber of courageous Chief Justice that we've seen in Maraga and the previous Chief Justice, Dr. Mutunga.
Thank you, Waikwa. As always, whenever we talk, we can go on. So, and these issues are very much still moving targets that are very live in sort of the Kenyan political milieu, and I think are going to intensify given all the realignments that we are seeing. So, I'd like to say asante sana once again for your time this evening. I'm sure we'll be speaking again. And continue to advise Kenyans who want to stand for different seats. Your opinion matters, and people are taking very seriously. Thank you, Waikwa.
Thank you, John. I appreciate. Asante sana.
Asante sana.